Hi, everyone. Welcome. Thank you for joining us for today's webinar. My name is Beth Cohen-King, and I'm the Marketing Director at Margolis and Bloom. We work with our clients to find the best estate planning or elder law solution for each client's unique situation and goals. We bring to this effort 30 years of experience and the commitment to providing the highest level of personalized service. So we are really looking forward to today's presentation. It's a very relevant topic, especially during this complicated work time. And this webinar is brought to you by Rebecca Pontikes of Pontikes Law. She has a passion for employment law and civil rights, which drive her practice. And our very own Sarah Hartline, who's a senior associate at Margolis and Bloom. So just some housekeeping. If you have questions during the presentation, please type them into the question box in your control panel on the right side of your computer. We will have time for questions at the end. And if for some reason we're not able to answer everything during the webinar, we do follow up directly via email. It may take us a few days just to process everything. And for some reason, if you need to jump off or you can't hear or something technically is going wrong, don't worry, we are recording the presentation. So with that, Sarah, I will let you take it away.
Great, thank you. Good afternoon, everyone. Thank you to everyone who is joining. I'm really looking forward to this webinar because it's a topic which I actually don't know a lot about, but it touches so many of us, especially those in that so-called sandwich generation who are caring for aging parents and caring for young children at the same time. As Beth mentioned, I'm an estate planning attorney here at Margolis and Bloom, so many of my clients are dealing with these caregiving challenges, which are certainly our full-time jobs in and of themselves, and then doing full-time jobs on top of that. You might actually hear some screaming downstairs from one of my kids in the middle of this, so I apologize in advance. But Rebecca and I actually first started discussing this webinar pre-pandemic, but it obviously is so much more relevant today, as Beth mentioned, with these additional pandemic challenges of closed daycare, social distancing restrictions. So I'm very excited, and I will now turn it over to Rebecca. And as Beth mentioned, feel free to ask questions as we go.
Good afternoon, everyone, and I'm really pleased to be doing this webinar because these issues which were always in existence are now suddenly making headlines, and we're having a social conversation about them. So I think it's really important to understand what this is and to know that you have rights, because many people still don't realize what their rights are. Many employers still don't realize what their rights are. You can see from the agenda here, I want to talk to you about something called Family Responsibilities Discrimination, what that is, bias in the workplace that comes up for caregivers, how employers might penalize you, what that might look like so that you know when your rights might be being violated, and what you can do to protect yourself and what laws protect you. And then we'll have some time, I hope, for questions at the end. Next slide, please. I have these facts about the workplace up here because it underscores how important it is to understand your rights. One in four or five employees are providing elder care. Many of these employees are men, contrary to popular belief. And there's things that caregivers need, like time off, alternate schedules, or working from home, that don't go along with what I like to call the ideal worker. Who's the ideal worker? He and she doesn't actually exist in real life, but in the popular imagination, the ideal worker is someone who comes to the office at 9, leaves at 5, does not have to deal with anything like sick children, old or aging parents, visiting nursing homes, parent-teacher conferences, or any sort of health issue at all. And in fact, ideally, the ideal worker never actually even has to use the restroom. But we all know that in real life that doesn't happen. And I put a bullet down here about employers not being prepared for this rise in employees that are providing elder care. And I did write this pre-pandemic. Because of the pandemic, we are now all talking about things like time off, alternate work schedules, and working remotely. And employers are becoming more aware, and it's becoming more normalized because for the past 60 days or so, we've all had to do it. So I think employers are starting to get more of a taste of it, and this may change the workplace going forward. It's unclear right now, but it's still important to know your rights, because what I've also been seeing in my practice is that the negative stereotypes about caregivers are still out there, and they're in many ways informing how employers are doing their layoffs or reducing work schedules during the pandemic. So next slide, please. So what is family responsibility discrimination? Well, it's not a law. It's actually a phenomenon that describes when employers discriminate against caregivers because of their caregiving responsibilities. And it could violate actually several different laws, and we'll get to that in a second. And when I say discrimination or penalizing, what I mean is firing, bad performance evaluations, putting you on a performance improvement plan, accusations that you violated a certain policy, selective enforcement of a certain policy, and all these things are rooted in caring for someone, a child, or in this case, somebody who's older. Next slide, please. So what I'm going to specifically focus on today is eldercare bias. And eldercare bias is a subset of family responsibilities discrimination. And as I have here on the slide, it's assumptions that employers make about employees who are caring for someone who's older. And this is a list of some of what those assumptions are. And these are also something I will call stereotypes. So, and this is something that I think is very, very common. And some employees even assume that it's okay to make these kind of assumptions about them because they're quote unquote just true, but they're not exactly true. They're not true at all, actually, in most cases. And there's a lot of acceptance of these when there should not be. Next slide, please. In addition to eldercare bias, sometimes a bias about caregiving will actually intersect with a bias based on race. And I have an example for you here. If we have someone who's Chinese, and there may be an assumption by the employer that this person will be less committed once the employer knows that this person has an elderly parent at home because of stereotypes that this supervisor employs about what it is Chinese families do to care for each other. So that's one example. There's other intersections with caregiving bias. Next slide. Because eldercare bias is done so often by people who are over 50, eldercare bias often is accompanied by age discrimination. So for example, if somebody who is over 50 is caring for a parent, the employer may assume that this employee is ready to leave the workplace and retire because they're over 50. So they may not give a flexible schedule to this person, whereas a young mother easily gets a flexible schedule to care for a young child. Next slide, please. Eldercare bias also often is accompanied by gender stereotypes. So I have two columns here, what stereotypes are that are shown towards women and what stereotypes are shown towards men. And I set this out specifically because these sorts of stereotypes can violate anti-discrimination laws. But let me go through what they are first. So with respect to women, these stereotypes are often, and I put in quotes here, benevolent, because it's not going to look like an angry, mean sort of behavior. But it's an assumption that a good woman will leave the workforce or retire early to give care to elders. Or there'll be an assumption that, of course, this poor woman needs a part-time position now because of all the caregiving that she has to do. Or, of course, this woman isn't going to want to travel, isn't going to want an extra shift, isn't going to want the more prestigious work because there's going to be so much on her plate already. We're doing her a favor by putting her in this position that may be lower paid, maybe a career ender, or may disadvantage her in other ways. So that's often what stereotyping will look like when it comes to women. And these stereotypes are still illegal, even if they look like they're nice. For men, they are more likely to see an antagonistic sort of reaction because employers are going to assume that men are going to pay someone to do the care for them, that they're not going to prioritize caregiving. And when men do these things or don't hire someone, they're met with antagonism or anger by their supervisors who think that a good male worker would, of course, hire someone else, probably a female, to do this sort of care. And again, this is a stereotype. This violates the anti-discrimination laws and may be a trigger that something illegal is happening if we see it. Next slide, please. So I have on this slide a lot of different ways that you might see a penalty come about in the workplace. So the stereotype that caregivers aren't going to be as productive, and that can bleed into how work is evaluated. And what I mean by that is, on your performance evaluation, your supervisor may start to pick on things that other people aren't being picked on and accuse you of not being productive, because what they're doing is they're thinking in terms of a stereotype based on caregiving as opposed to objectively evaluating your work. You may also be discouraged from leaving to give care. And what that often looks like is statements like, you know, the team's going to be awfully put out, or, you know, you're really putting a burden on your coworkers by doing this. And those are all subtle ways to discourage an employee from taking leave to give care. And there's, of course, also terminations for an employee by an employer because an employee has requested leave. And while that's illegal, and we would hope that that doesn't really happen so blatantly, from my experience and my practice, unfortunately, it does. Declining requests to work flexibly for caregiving reasons, although they are allowed for other sorts of reasons. Some supervisors will design a work schedule that specifically interferes with caregiving, whereas somebody else who wants a flexible schedule for a non-caregiving reason has no problem getting that. Harassing employees who take time off to give care for aging parents. That could take many forms. Calling on a company's cell phone incessantly during a period of time when they know you're going to be out of work. Calling or sending you emails on a time when you're out of work and giving care, asking for an immediate response and forcing you to work on that sort of time. And of course, the old standby, fabricating work infractions to justify dismissing caregivers. And that could be selective enforcement of rules that other people don't have to abide by. That could be a performance evaluation that weights mistakes far more heavily than they are weighted for other employees, things like that. Next slide, please. So here I have some additional examples. Sudden strict application of workplace rules. You know, if it was never a big deal if you came in at 9 or 9:05, once they know that you're having to set your elderly parent up in the morning before the paid caregiver gets there, suddenly getting in at 9:05 is no longer acceptable. Caregivers can often be marginalized. They don't get good assignments anymore, not invited to meetings, left off in emails so that they don't know what's going on. And these things all might happen when you've notified your supervisor that you're taking some time off to check out a nursing home for your parent, or, you know, you're 15 minutes late, like I was saying, to, you know, hire a caregiver was late. Next slide, please. I have here some of what I call loose lips comments. And these are indicators of bias. So statements that I alluded to before, people often think are just true, but really aren't. They also illustrate some of the benevolent stereotyping that I was talking about. So a supervisor says to you, wow, it's really hard to be taking care of someone with Alzheimer's disease. They need you 24/7. You must not be able to think about anything else. And while that may be meant in a sympathetic way, it is potentially an indicator that your supervisor might evaluate you differently. Now, if you get this sort of a comment and nothing bad ever happens to you, maybe they meant it in a nice way and they're fine. But if your next performance evaluation contains a lot of poor evaluations that reference your distraction, or you're not focused, or you don't seem to be all in at work anymore, that could be an indicator that what your supervisor said to you in a nice sympathetic way is affecting his or her ability to evaluate your talents objectively.
Rebecca, do you mind if I jump in with a question?
No, please do.
So, for employees that are sort of bumping up against these issues at work where they have, a supervisor that they feel like is doing a lot of these things, saying a lot of these things, do you have, and I don't know if you're going to get to this later, but are there any recommendations about what they should be, sort of doing, or, how they should this sort of immediate reaction? Maybe it's just starts off with a lot of little comments, but then they're, hearing them more and more often. What should be their sort of immediate steps when it's happening?
So I am a big proponent of take good notes. If you, you hear something once, maybe it's a little weird. If you hear it again, write it down in a notebook that you keep at home or something like that. And keep a watch on how that's affecting the assignments you get. If that's suddenly you find yourself off of emails, keep a timeline. What's happening? When is it happening? If these things all start to accumulate, or you see that you feel like you're being treated differently, how other people like you have been treated is very important. So ask around, or people who aren't in your particular situation, ask around. If your supervisor seems to be treating other people differently, if you have one-on-one meetings with that person, bring it up in the meeting. Ask that person if it seems to be, and try to work it out. And again, document this sort of thing. If there is an issue, a supervisor says something about it, send a friendly email afterwards to say, okay, here's the plan, and put some bullet points down. That keeps everyone on the same page, and it also keeps it documented so that nobody can deny that this is what happened later.
Great, that's helpful.
Yeah, if some employers have an internal grievance process, and if it gets to the point where you don't feel you're working well with your supervisor, use it.
Great.
Next slide, please. There we go. So this is a particular issue. I call it second supervisor syndrome, and I'm glad Sarah just brought that up about what to do, because sometimes in the workplace, you'll have a supervisor that you've worked with for many years who has an informal arrangement with you, knows you have an issue, knows you have to take time off, and it's worked well. You have an informal arrangement. Nobody went through human resources. You just worked it out, and everything was fine. But what if that supervisor leaves and you get a new supervisor who isn't familiar with you, who maybe doesn't want to allow this informal arrangement to persist? And that's what I call second supervisor syndrome. And what the new supervisor might do are things like, instead of this informal arrangement you had with your old supervisor, require formal FMLA requests for time out of the office, which would cause you to use up your FMLA time, which is limited to 12 weeks. In Massachusetts, we are, as of next January 1st, going to have our paid family leave time, and they may require you to start taking that. These sorts of changes, while they might be technically allowed, could be indicators of bias, because sometimes, even though they're technically allowed, they're being done to force you into a position where you don't have any more time to use, and they can force you into a position to either stop taking time off, which they know you can't do, or quit. And what Sarah just asked was a very good question, because, what happens in those situations? What do you do? Well, one of the things you can do is sit down in a one-on-one and address it with your new supervisor. What makes them comfortable? If you can't work it out with your new supervisor, you can go to human resources or use a grievance process. And the reason I was telling you about all those loose lips comments is because you start to hear those kinds of things, it may be time to alert HR unmistakably by dropping the word being discrimination. Because HR often likes to pretend that they don't know what you're talking about unless you actually use the D word in front of them. Next slide, please. Okay, so what are these laws? This is a list of them. The first two are Massachusetts specific. And the Small Necessities Leave Act is also Massachusetts specific. The other ones, particularly Title VII and the Family Medical Leave Act, are probably familiar to you. Next slide. Next slide, please. So, anti-discrimination law. I went over all those stereotypes before because it's very important to know that the application of those stereotypes violates both federal and state anti-discrimination laws. All these assumptions are based on sexist stereotypes, and that's just as illegal as treating somebody different just because she's female or just because they're male. And so I have here, for example, asking a man, why don't you pay someone to care for your mother? Well, that's based on the stereotype that men aren't supposed to be doing this. They're supposed to pay someone to do this. And that's illegal sex discrimination. Next slide, please. Associational discrimination. You may not have heard of that. It is little known, but it is probably the most important law to know about because it's the easiest to see and prove. And there are employers, even large, sophisticated ones, who are unaware that that this law exists and who haven't given managers training about it. So what does that mean? What it prohibits is you can't discriminate against someone because of their association with someone who has a disability. And that doesn't have to be a family member. It can be a friend. It can be a life partner. So for example, LGBTQ couples that have decided not to get married, might still apply to them. This could be a parent who has Alzheimer's disease. This could be a grandparent who has Parkinson's. It could be a family member who's an alcoholic. Your employer can't discriminate against you because they know you have that person in your life. So in my second column, I have another important thing to know. Do you have a right to an accommodation or a flexible schedule because of your association with this person? Well, the short answer is no, but there's a longer answer, which is that an employer can't allow modifications of schedules for people who aren't associated with a person with a disability, but deny it to someone who is. So if your employer modifies job requirements for someone with a young child, but they refuse to do it for someone with a parent who has dementia, that could be a sign of associational discrimination. And employers also, those assumptions and those stereotypes I was talking about before, they can't make those towards somebody who just because they're associated with somebody who has a disability. The indicators you might see of these that associational discrimination is happening is lots of concerns about higher health insurance premiums, assumptions that you'll be distracted, again, that distraction issue, assumptions that you might carry a disease into the workplace. COVID-19 might fall into that category. It's unclear. But for example, if you have a relative who has HIV and your employer is now suddenly worried that you're going to carry it into the workplace, that's a definite indicator of that. Next slide, please. Okay, Family and Medical Leave Act. I'm going to run through this quickly because there's also some specific information that changed with the CARES Act. And I think a lot of people are already very familiar with this. So you do have your 12 weeks of unpaid job-protected leave to care for your own or a family member's serious health condition. Your employer can't cancel your health insurance coverage. They can't change your job. And if you come back, you have to have the same benefits. The bad part about the FMLA is that you have to work for a company with over 50 employees, and you have to have worked for either a year or 1,250 hours. Next slide. Serious health conditions can be any physical or mental health condition. Most chronic conditions that elders have fall into this category, and your employer can require a certification. And I'm going to take a short detour here to the CARES Act, because there's some very key changes in the CARES Act. The CARES Act is applicable from April through December 31st of this year. And the CARES Act is applicable to any employer with 500 employees or less. So even if you work for an employer with 25 employees instead of 50, that will apply to you. You do get 12 weeks of leave, but that leave is going to be paid, not for the first 10 days, but it will happen for the next, if you have to take time more than 10 days off, it will apply after that. And this is for people, now that we're opening up, this is going to become important. If you can't go back to work because your employer is reopening, but your childcare or your eldercare services aren't, this will cover you through the end of the year. So that's very important in this stage where we're all kind of halfway opening, some are opening, some aren't. We're not sure what's happening with childcare. You still should be able to take 12 weeks under the emergency provisions of the FMLA. So I think I wanted to take that little detour because I think that's particularly important as we all start to kind of sort of maybe piece by piece open up.
And Rebecca, can I just ask a question in terms of, and just in terms of these, taking leave in general? One thing that I hear from other parents is that even when they are, taking leave time, that they're often expected to be making up that work, whether it's an unpaid or a paid leave day, or fearing, receiving some sort of feedback for not meeting their job requirements. So from a legal perspective, do you have any sort of, advice in terms of, these employees' options? I guess what I'm trying to say is, in this example, in terms of, with the child care, needing potentially to take leave time to take care of kids, but then being expected, the next week to do twice as much work when they're back.
So that's a complicated question you've asked.
Sorry.
Well, because there is no strict prohibition on that. They can't, there's no law that requires your employer to adequately staff it and have somebody do your job while you're out. And this happens a lot, and you see this phenomenon happen a lot. However, if you've taken your leave, either under the CARES Act or under regular FMLA, and you come back and your employer starts to overload you in a way that's unreasonable, but in a way that it doesn't do that for people who have come back from vacation, for example, that could be a case of retaliation, which is prohibited both with the expansion by the CARES Act and by the FMLA. Can we advance to the next? I think I have, this is who you can take care of. But retaliation is prohibited. And under the FMLA, interference is also prohibited. So if your employer warns you before you go out that, I'm going to expect that you're going to put in double time next week, that could be interference, because it could be that they're trying to discourage you from taking it, and that's illegal. The other to your question is that it really depends on if you are salaried or hourly. Hourly employees want you to work double time when you come back. That's great, but they're going to owe you time and a half. So they're less likely to do that. What those employees are more likely to see as retaliation is a cut in hours.
Okay, great. That's very helpful.
Yeah. So this next slide is showing who you can care for. And if anyone has a military member of their family, pay close attention, because the FMLA does give special protection to anyone who is caring for someone in the military, whether it's a good friend, a cousin, anyone who's more distantly related. If they're in the military, you get 26 weeks instead of 12, and they don't have to be a blood relation. Next slide, please. Okay, I wrote this slide because these I think are key rights. And this is where I was talking about a little bit before: no interference and no retaliation. And we're getting short on time, so I'm going to have you go to the next, please. I'm going to go through this very, very quickly. I'm sure everyone has been talked to by their employer about the Massachusetts paid leave law. And it's going to go into effect on January 1st for childcare and January 1st for July 1st for care of another family member. That would be the Eldercare part that I was going to emphasize that I'm emphasizing in this presentation. These are some key rights. The good thing about it that makes it better than the Family and Medical Leave Act is that it covers all employees in Massachusetts, and there is no waiting period. I'm not going to go through how the calculation is made for how much you will get, but it is very well set out on mass.gov. If you look for the Worker's Guide to Paid Family and Medical Leave, they take you through it step by step, but we don't have enough time for it today. It's a little bit complicated. Next slide, please. Massachusetts has a little-known law called the Small Necessities Leave Act, and that covers employees employers with 50 or more employees, and it allows you to take 24 hours of unpaid leave every 12 months. And this can be to accompany your elderly parent to a medical appointment or your child to parent-teacher conferences, but it has the same eligibility as well as size requirements as the FMLA, but it only applies to Massachusetts employees. Next slide, please. So this is my key takeaway slide. So if you don't want to download this entire presentation, if you only want to download this slide, this gives you all of the laws that might apply to you and some actions that we've gone over today that indicate potential bias. I hope that everybody got something out of this today. Because I'm looking at the time and I want to be mindful. Sarah, do you have any other questions, or should we open it up to questions from others?
Yeah, this was great. I certainly learned a lot. I don't know if there's any, I don't think I see any questions in the chat, or can you, Beth? I don't know.
Yeah, there are two. There's a comment and a question. So.
Oh, okay.
Yep. So.
I'll let Beth go ahead then with the question.
All right. So. This is a comment here, and I'm sure you can elaborate on this. It's vitally important to broaden this discussion to include working parents, including those with special needs children. There is a hidden bias against this population, plus employers are increasing benefits and supports for new parents, failing to recognize that parenting needs intensify as children grow older. Also, employers tend to be more understanding of elder care needs than of parenting needs because elder care has a more defined time period, whereas parenting is for decades.
So that's absolutely right. And I think that everything I have said today about elder care applies pretty much in the same manner to parents of children with special needs. There is the same sort of antagonism. There's the same sort of benevolent stereotyping towards women and antagonistic stereotyping towards men. There is also that same assumption that your special needs child is going to take up your time and distract you from work. So for example, if you take a 15-minute break to take a call from your child's school, that may be viewed very negatively, whereas somebody who takes a cigarette break, no one even notices. Or someone who spends 25 minutes yucking it up at the water cooler about the latest episode of whatever the show du jour is. That's not a problem, but a short break to deal with something that your child needs is. So that is a very, very good point. A lot of what I've said today applies equally. And I would say that a lot of the data that I have seen shows that elder care is actually is met with much more hostility from employers, particularly towards men. There seems to be more of an assumption, at least from the data I've seen, that employers think that particularly men should be hiring others and not doing any part of it themselves. But that is a very, very good point. I'm glad that person made it.
Okay, there's additional question here. It's just probably you can answer very quickly. Does the 1250 hours or 1 year apply for the CARES Act?
No. You only have to have been employed by the employer for 30 days. And it was 30 days as of, I think it was April 1st when it kicked in. So no. And you can use 12, and it's also 12 weeks. It will be paid. But something to know is that you don't get to stack the 12 weeks in the emergency expansion plus another 12 weeks of FMLA. So if you used before the April kick-in date of the CARES Act, say 3 weeks of FMLA leave, under the CARES Act, you've now only got 9.
Okay, great. I'll just add, that was all the questions, Beth?
That was all the questions that I see right now.
Okay.
Oh, and for
great.
the person who asked about the CARES Act, I just want to say my website is on the slides. I do have a whole bunch of slides on my website that are very specific to COVID-19 issues, including the expansion of the Family Medical Leave Act under the CARES Act.
Great. Yeah, I just have a general question, which is not really a legal question, but I wonder if you think that in terms of, I've heard a lot of people talking about sort of the long-term effect of the pandemic in terms of employers, sort of being forced into these more remote-friendly workplaces, which maybe, are potentially more, friendly towards, people that have, caregiving responsibilities at home, whether it be, elders, parents, or children. So do you have any sense of whether, there might be a long-term positive effect or I don't know. I'm just curious as to your thoughts.
Really good question. I think there will be a long-term effect. I think it's unclear what it is or if it will on the whole benefit workers, because certainly employers are seeing the benefits of remote work. And I am positive that once now it's been, almost 60 days, they've had enough time to see how things work. If there are some things that work well remotely and are more productive remotely, I expect a lot of employers will keep them in place. But when talk about remote work for caregivers, we're thinking, employers will do things that will help caregivers. Maybe not. Because employers are going to look at, in my experience, when employers apply a new concept to the workplace, it's so they can advance their own interests. Whether the remote work that we've gotten used to will be applied in a way that benefits caregivers remains to be seen, but certainly the concept of work and the discrimination against it or the assumptions that it was inferior to being in the office, those I think are going to go, I think have gone away. I think it will be used much more, I think it's going to mainstream a lot more quickly than it had been.
Great. Well, that was very helpful, and I certainly learned a lot. So thank you so much. And I think I hear a child downstairs starting to melt down, so it's perfect timing.
I've had two already come into the room. Okay, so I just want to wrap up with thank you to both of you. Super insightful and so many things to think about and just be cognizant of as we reopen and we re-enter the workplace. So if you do have follow-up questions, here's you can see Rebecca and Sarah's contact information, phone numbers, websites, and all of the good stuff. So with that, I think let's go enjoy the rest of the beautiful day outside. So thank you both.
Great.
Both of you. Okay.
Thank you, Beth. Thank you, Rebecca.
Okay.
Bye.
Bye.